That's a very good question, and it's a common one. In many divorce cases, one or both parties will indeed own a business. To properly evaluate what these properties are worth, you must retain an expert. The court will either appoint or the lawyers will choose a qualified forensic accountant who will be retained by the parties to determine the fair market value of that asset. The forensic accountant normally will interview both parties. They will examine the books and records of the businesses. They will talk to the business accountants. They will then render a report setting forth what the fair market value of the business is. Then there are negotiations as to what percentage of that business the spouse would be entitled to. Whether a business is acquired during or before a marriage, the spouse is entitled to a percentage of that business, but possibly less if it was a pre-existing business. The forensic accountant will determine the growth of that asset from the day of the marriage until the day that a complaint for divorce is filed. In most cases, a party who is not the owner or operator of that business and did not work in the business during the marriage would be entitled to less than 50% of that value. That spouse who did not own the business would most likely be entitled to somewhere between 30 and 40%. 1/3 is kind of the agreement that most courts come to these days.